up to 2 years after the close of escrow. That tells you a lot, Now they're telling you, if you're dealing with an investor, there are certain disclosures that the investor has to give the seller. And let's go to your booklet. See if I find it. Does anybody find it?
Yeah.
Anybody see it?
What is it, default purchase agreement?
Yeah. Page 12?
12.
Okay, let's go to 12. You see that there? These are the disclosures that the investor has to give the seller.
There's no page 12 here.
What do you mean there's no page 12?
That's the notice of
They're in
receipt.
the half a
It's in
book.
the other packet.
In the other package.
The other book.
They're in the other booklet where it has my name, Joe Ramos. You got it? You see, the reason I have them because everything changes. Okay, this notice of default, enter date of contract. You, seller, may cancel this contract for the sale of your house without any penalty or obligation at any time before, enter the date and time of day. To cancel this transaction, personal delivery, a signed and dated copy of this cancellation notice, or send a telegram to Joe Ramos Investor at whatever Whittier, no later than time and date. I hereby cancel this transaction. By law, you have to give the seller this notice, the investor. By law, in duplicate, the notice of cancellation, you have to give it. Now, what really gets to me is there are a lot of real estate agents out there dealing with investors on short sales, and they don't know diddly about California Civil Code 6095. That's a good way to get in trouble. And I've seen it. I was doing a class about a month ago in Orange County, and one of the brokers comes to me at the break. Hey, Joe, it's happening to me. Tell them this is important. It's important. But no, you guys take it very lightly. Now watch this. The law does not apply if the buyer is a bona fide buyer, right? What does that mean? He's going to live in the property. The law doesn't apply if it's the seller's rental. It has to be primary residence, owner occupied. The law doesn't apply if there's no notice of default. So all four items have to be there for it to apply, right? Okay. Watch this. This happened to a real estate agent, several real estate agents. You're working on a short sale, there's not a notice of default. A week before you close escrow, whammo, they record a notice of default. What are you going to do?
Do all this.
Huh?
You have to do all this.
Well, I got to tell you about certain cases. One in Riverside. A judge in Riverside made a decision that if they signed a contract and there's no notice of default, the law doesn't apply. After they record the notice of default, after they sign it doesn't apply. But that doesn't mean diddly. Because that came from a small court. CAR attorneys are telling me to tell you, if there's no notice of default recorded on the piece of property, and then a week before they close, they record it, and your buyer's an investor, and it's 1 to 4 units, owner occupied, treat it like it applies. Because you don't want to be the first one they test. Am I correct? Okay. Any questions on this?
I got a question. Just basically, what is this? These laws come into for a reason. What's the protection here?
To protect the homeowners that are on default, because some of them are stressed out, and there's a lot of scammers out there that come and try to take away the. It's still happening.
Civil code.
So this came out. I used to buy a lot of homes myself. I used to follow the notices of default. I never took advantage of anybody. Okay? I play it straight. But when this law came about, all the ones that were scamming the homeowners, they weren't around. But guess what? They came back. So this law is California law. It's almost like the Mars federal law. The Mars federal law also came out to protect the homeowners that are in distress selling their home.
Gerald,
Yes.
okay, I'm trying to write it down. Are you one of 4 units NOD has been recorded?
Okay, I'm going to tell you.
You're going to let us know?
Don't write it down. No, no, no. Go to car.org.
Okay.
Get the Q&A on the home equity sales contract law.
Okay.
Also get the Q&A on Mars.
Okay.
The contract law?
Yeah.
So in this thing, it says 5 days cancellation period, it's got 2-year contract rescission period. They have a right to void. Then what happens in that period of time?
Okay. Question is, because he's here in the front row, he's seeing that the seller has a two-year rescission period. If the seller finds out that they took advantage, unconscionable advantage of them, okay, he has 2 years to rescind the contract. But you know what happens in the properties? They flip them, right? So they don't have them anymore. So that means they have 2 years to bring a lawsuit. Okay? And they're going to win.
Where are they going to get the money to
Property value goes up.
rescind? I mean, if they rescind the contract, they're going to have to give the purchase price back. Where are they going to get that?
Purchase price? No, they don't have. That was fraud. They found out somebody did something wrong. They violated Civil Code 6095. Attorneys will take those cases for free.
Beware if you're a buyer of the investor.
Oh, how about this? Let's see if you know your liability. You're the listing agent. My buyer here is going to buy your short sale. We make an offer. What is he? Is he a bona fide buyer? Or is he an investor? Well, he's telling me he's a bona fide buyer, and in the contract it says he's not intending to what? Live in the property. So how am I going to treat him? Investor. It's up to you, because let me ask you this. What is the first form you give a buyer or seller? Say agency. When you give them that form, what are you telling the buyer and seller? Not yet. You tell them that on the confirmation. You're telling them you have a fiduciary duty with them, and your job is to look for their best interest. Am I correct?
Correct.
So if you know he's coming with an investor, and he doesn't know about this law, you as the listing agent, should you come and let him know that they have to comply with it? Yes. Oh, I'm going to go further with it. The investor, we already know what the penalty is. A $2,000 fine, a $2,500 fine, or $25,000 and 1 year in jail. We know what that, okay? But the agent that's representing the buyer has some duties to perform under this law. One of them is to notify the seller in writing that you have a valid California license, real estate license. Showing your license to the seller is not enough. It has to be in writing. And CAR has a form for that. A long time ago, and maybe you guys are not aware of this, he had another duty. The agent representing the investor had to be bonded 2.5 the value of the property. 2.5. 2.5, yeah. The value of the property. They have to be bonded. But guess what? You couldn't find this bond in the state of California. So attorneys were telling you, do not represent an investor because you can't comply with the law. You could show the seller you have a valid license, right? But where are you going to get that bond? So I tried all kinds of ways to go around that bond, but I couldn't. So finally, the court heard this case and said this is unconstitutional because real estate agents cannot get that bond anywhere. So they eliminated the bond. Isn't that great? Now you could represent an investor if you know what disclosures that investor has to give your seller. And it's very important. Any questions on that? Yes, sir.
Back to the 2-year rescission.
2 years, yes, sir.
Okay, seller flips the property. What is...
Buyer flipped the property when he bought it from me.
Right, okay. Now, the person buys it, he's subject to the 2 years rescission.
It could be a mess.
What, title insurance going to bring that out or not?
You know title insurance? Yes. As a matter of fact, some title insurance put a little clause in there. If they come back, they're not covered for that.
So they will bring it out?
Oh, yes. Yes.
Well, that's a really...
I know!
Well, that's a dangerous sucker.
Yeah, but real estate agents don't even look at it that way.
They want the commission.
Yeah. That is important, guys. What I'm telling you this morning is very important. Yes, sir.
Another question. It says on here, it says, if certain provisions of these codes are violated. I mean, obviously this has to do with, not just because you forgot to have somebody sign a form, you're not going to go to jail.
No.
It's about fraud.
Yes.
So if you're not participating in fraud, you're not, I mean, of course you should have somebody sign something, but.
Yeah, because it's law for the sellers to sign those forms,
It
right?
has to be, the fraud has to be proven.
Has to
Yeah.
be in court.
So the whole thing about this two-year rescission thing is just if there was fraud involved.
Exactly.
Which has to be proven.
And another one is if they didn't get those forms, they could rescind it.
Say this.
They don't have the form?
Yeah.
Well, the seller sells for $100,000 profit.
Yeah.
Come back and buy it.
Oh,
And
yeah.
they have,
One of the
You
questions
see, let me tell you what this law was to protect the seller's equity. There's no equity here, right?
right.
But it still applies.
So the buyer of the new property, they wouldn't be involved in the lawsuit. then?
Good.
They could.
But they're gonna be a bona fide purchaser.
Yeah.
They should be protected.
A question.
Yes.
Can we waive the 2-year?
No, you cannot waive anything. You cannot waive anything. I'm glad you said that. Oh, here's another one. Ooh, we got a bunch of them. How many of you have heard the foreclosure consultant law?
Well, I
Ooh.
have a question.
Yes.
Backing up to the notice of
The rescission.
rescission, the cancellation. Sorry. So you're presenting this, because I've done it, with the NODPA.
There you go.
So what dates do you put in there? 5 days?
At the time that they signed the contract.
So do you say after acceptance or?
Yeah, when they accepted it, okay? When they accepted
This
it.
doesn't apply until they've accepted it,
Exactly,
right? What
exactly.
if they don't accept it, but it goes with the offer?
It goes with the offer.
Yeah.
So what dates do you put in there?
Put the date that you put the offer, but, I mean, put the,
But it's asking for the date of
Yeah.
cancellation.
okay.
So they have
It's
5 days.
five business days from the contract, okay? Date of the contract.
From acceptance of the contract?
Yes.
Okay, so we
But
can-
you
we
don't
can
know
put
that date before.
You don't know it, but
But we can put that wording in there?
you could do it later on and give it to them.
So you're saying that you don't have to present this with the offer?
You don't have to as long as you give it to them,
Okay.
okay? as long as you give it to them.
So you don't have to have a date in there up front.
No.
But it says on here that this notice is to be completed by buyer prior to presenting the agreement to the seller.
By buyer? Yes, it has to be completed, okay? But you don't have to give it to them right away,
Okay,
as long as you give it to them,
okay.
okay? Where was I now?
Foreclosure consultant.
Oh,
Sorry, Joe.
that's okay, foreclosure consultant. How many of you have heard of that? Now I gotta tell you about something else. Oh, by the way, he's recording this. I'm not giving legal advice, just information. Okay? So there it is. This is good. Remember the advance fees? Remember those advance fees? Remember a lot of real estate agents were charging up front to do a note modification? Remember that? That's why they added to this law. For somebody to collect advance fees, they could do it, but they have to be registered with the Justice Department. And I'll tell you, the Justice Department is not going to approve everybody. Okay? This applies if you charge up front, okay? I used to do note modifications. If I charge up front, I became a foreclosure consultant. If I stopped a foreclosure and I charged up front, I became a foreclosure consultant. Anything I do to help the homeowner that's losing his property and I charge an advance fee, I'm a foreclosure consultant. And the foreclosure and you know what? To this day, there's still real estate agents out there charging for advance fees. Do me a favor. If you know somebody, give me their names and I'll turn them in. I'll do it. I'm not afraid. But here it is. Foreclosure consultant. It's harder to do now because a lot of brokers are afraid of this now. A lot of brokers will not allow their real estate agents to charge any monies up front. Number one, the Justice Department has to approve you. And if you know anybody that hasn't been approved by the Justice Department to charge advance fees, and you could go in their website and find out the lenders or the ones that are allowed to charge advance fees. But they become a foreclosure consultant. And they have to comply with this law, and it's almost identical as California Civil Code 1695. Same rescission period, same stuff. So this is this here. Any questions on this? So I bet some of you are thinking, I'm not going to do a short sale on. Is that what you're thinking? No. As long as you know the laws and do it properly, you'll be okay. It's the real estate agents that don't pay attention and don't come to my classes. Those are the ones. Okay. Now, I'm going to talk about something that you guys don't even think about in a short sale. A lot of you that work short sales are working for free. I'm going to tell you why. Does anybody know the definition of a binding contract?
Yes.
Offer acceptance of consideration.
Buyer offers, right? Seller accepts. Seller accepted the offer. Do we have a binding contract?
Yes.
No.
No.
Not until the confirmation of acceptance goes back to the buyer.
Then all compliances have been taken care of.
Right. Now watch this. Buyer offers, seller accepts, but the confirmation of acceptance hasn't gone back to the buyer. Can the seller sell it to somebody else?
Yeah.
Can the buyer back out? So you don't have anything, right? Watch what happens in short sales. Buyer offers, seller accepts, everything goes to the lender.
Yes.
What happened to the confirmation of acceptance that goes to the buyer? I'm going to tell you what I do. I'm not an attorney and I don't give legal advice, but a lot of real estate, let's say, your name, sir? Lee. Let's say you call me and say, hey, my buyers are tired of waiting and they want to back out, but the listing agent says if they back out, they're going to sue you. Right? Okay. I say, Lee, did you ever get the confirmation of acceptance to you or your buyers? No. You don't have anything. Can the buyers walk and get their deposit back?
Yes.
You guys leave it open. Why do you do that? Yes, you got to have a binding contract. And 90% of all short sales, you don't have a binding contract. Because the confirmation of acceptance never went back to the buyer. Can the buyer walk?
Yes.
I tell Lee, tell your buyers to walk and get their deposit back. If somebody tells you different, like listing agents, oh, you can't do that? Well, what happened to the confirmation of acceptance? So we don't get the confirmation of acceptance. We don't have a binding contract, do we? Do we? No. A lot of you do that. A lot of you also do this. I wonder what this stands for. Countrywide. I know they're no longer around. But I'm going to tell you the short sales that will never close. I don't care how much you know about a short sale. When Countrywide was around, what did they used to do with their loans? Sell them to, right?
Mortgage security.
Sell them to a governmental agency, Fannie Mae, Freddie Mac, right? Okay. As a real estate agent, if I'm working a short sale, can I find the decision makers over here? Say yes. I don't have a problem. An option they have is keep it in their portfolio, right? Can I find the decision makers? Say yes. Over here we have a mess. When they were sold to Wall Street as securities. I'm going to tell you what happened here. Who told me? My son-in-law.
What does he do?
These were sold not only once, not only twice, but 3 or 4 or 5 times around. Well, who are the owners of that note and deed of trust? Do we know?
No.
Let me show you what example we have. Frank, did you show me this with a dollar bill? How many times you could sell it? No, you didn't. I'm going to show you something. This is a note, right?
Correct.
It's in a note? I could sell it to you, right?
Correct.
You take it, you could sell it to him, right? You take it, you could sell it to him, right? Check too, right? A check too, I could sell it to him. So we could sell it. That's what happens to these loans. Nobody knows who the owners of those notes and deed of trust.
Thousands.
So, you need anything, sir? Okay. So here it is. How many of you have waited on a short sale 5, 6 months and it didn't go through? Thank you. It was probably here. You see, to me, this is a waste of time. Because you will never find the owners of that note and deed of trust. I'll prove it to you. How many of you saw Bank of America that on 60 Minutes?
Yeah.
Remember that they were forging that lady's name?
Lane?
Yeah, I remember that. That's because they can't find the owners of this. Now, if you work on a short sale here, are you going to close it? If I get a short sale that's here, I'm going to refer it to you. I don't want to deal with it. But here it is. How do you find out where they are. Fannie Mae and Freddie Mac have a website, am I correct?
Correct.
How many of you have used it to find out who owns that, right? Very simple. There's another way of finding out. I don't know why some real estate agents have a hard time and some don't. I never have a hard time by asking the servicer, was this loan sold to a governmental agency? Let me check for you, Joe. Yes. Or was it kept in their portfolio? Let me check for you. Or was it sold to Wall Street securities? Once they tell me, if it's here, I will work the short sale. If it's here, I'll refer it to you. See, that's one of the biggest mistakes real estate agents do. And then they wonder how come it didn't close.
So the three questions were, was it sold to a governmental agency, was it kept in their portfolio, and then you said, was it sold to Wall Street?
The what?
And the third question was it sold to Wall Street? Is that what?
Was it sold to Wall Street as securities?
Okay.
But those are mostly countrywide loans, right?
Huh?
Those are mostly countrywide loans?
A lot of loans. A lot of loans, especially mortgage companies like Countrywide. They to make money, they got to sell their loans, but they keep the right to service them. Yes.
So what do you think is going to happen? Are those just eventually going to foreclose?
Well, let me tell you what happened on 12 loans that were here and they foreclosed. A judge overturned the foreclosures because they couldn't find the owners to the original note and deed of trust.
They still haven't solved that.
Huh?
They still haven't solved that.
They still haven't solved that. And it happened, what, 3 years ago? 3 years ago. So it's a mess.
People in their houses went out 2 to 3 years without being foreclosed.
I know. It's a mess. So guess what? When you jump and work on a short sale here, what are you going to have? A mess. Okay. Okay. Another mistake real estate agents do. How many of you know HUD 1? You know what a HUD 1 is? No.
I've done one yet.
Okay, he's brand new. No, come on. I told him to sit in the front. Watch what escrow tells me. You're working on a short sale. Let me find it. You're working on a short sale. A first of $500,000. A second of $150,000. All right. Let's assume that you take care of the first and the second. They agree. The second takes so much money. The first is willing, right? So you have an approval. But the last minute, there is a judgment against your seller. And we didn't know till the last minute. Does that happen?
Yes.
Isn't it true that I have to redo the HUD? This is what escrow people tell me. Joe, I get so tired of real estate agents. We got to amend those HUDs because they never include all expenses. What do I mean by all expenses? Let's define expenses. Is your commission an expense?
Yes.
Cost is an expense?
Yes.
Homeowners Association dues, is that an expense?
Yes.
Attorney's fees, if there's one?
Yes.
How about this? A judgment? Mechanics lien?
Yes.
Alimony child support lien?
Yes.
Are those expenses?
Yes.
Why in the world don't we include all expenses from day one?
Don't know.
Huh?
You don't know about it.
Well, you got to find out. How do you find out? Huh?
You have to ask.
When you take a listing, take a statement of ID. Tell your sellers to fill a statement of ID. Give it to your favorite title rep that's knowledgeable. and they will run a GI, General Index, will show anything against the name. And anything that's against the house. Now, if I have all those, are real estate taxes an expense?
Yes.
You're going to laugh at this. I get this call every other day. Joe, I'm working on a short sale. Who pays the real estate taxes? Oh, that hurts me. Who pays the real estate taxes? The seller! You see what I come across?